Welcome. You're on mute. I think you're on
Thank
mute.
you so much. I'm here.
All right. Welcome, my
Yes,
brother.
season's
Welcome.
greetings, my
Let me
brother. Mm,
season's greetings to you. Season's greetings. I see you're smiling. We are
mm,
smiling as well. And
mm,
thanks for the accepting the invitation to be and speaking out this afternoon. And the reason why we invited you because we believe, as one of the defense counsels, that you can give some another perspective. You know, we were defendants, and people
mhm.
might believe that we were a little biased, yeah, and are still biased in our presentation. But we want to have, if we can call it that, an independent view for you to tell the audience, tell the students, we call them, exactly what transpired during the course of this trial. Please, the floor is yours. Go ahead.
I want to begin by saying that it has become a very worrying phenomenon in Guyana, where charges are laid, but the persons who are responsible for the instituting of those charges are not really concerned about a conviction at all. They're not even concerned about whether the charge will get past a no case submission. Charges have become in Guyana a thing in which you do in the event that you want to silence someone or you want to drive some form of fear. So the instituting of charges now have become a tool which is used against people without any proper care. And the worrying thing about it is that persons will say, you get past the police investigators. Let's say, for example, the police investigators had some form of ulterior motive in which they were using to institute these charges. My concern goes way beyond that. My concern is that these matters at some point in time would have had to receive advice, whether it's advice from the police legal advisor or advice from the director of public prosecution's office. Now, our DPP might be very, very, very busy. So let's give the benefit of the doubt that these files never appeared on her desk for her personal view of the charges. But there are lawyers who sit at the director of public prosecution's office, and some one of them would have had to, I believe, look at these files. And I want to say that they are codes which guide the instituting of charges and guide the actions of the director of public prosecution's office. And those codes have been signed on and received and even echoed as being very good codes by our own very DPP. But there are two tests to this code. The first one is that there is the evidential test. And the second test is the public interest test. So when one looks at a file, one looks to see the evidential weight coming out of the matter to say whether the facts disclose enough that it is can be comfortably put before a court. And in going through that evidential process, it is incumbent on the attorney, the state attorney who is reviewing the file at the director of public prosecution's office, to have all the disclosures made to them. Now, in this particular case, you heard clearly that Soku held back certain documentation, and I would say that they held back facts, and they did not disclose all the facts. Now, I would think that the prosecutor who prosecuted the matter would have disclosed at least it appears so, that he would have disclosed all that was in his possession. Now, I'm saying that because it seems as though we were not the only person who was very surprised at Superintendent Kendall's evidence. But it seemed as though the prosecutor was also surprised that the very office which he is representing and prosecuting their matters, that they were in possession of vital facts which clearly did not go before the Director of Public Prosecution's office and clearly was not put before the court. And clearly it was not disclosed to the defense. And so even if we put that aside, we started this matter by saying, and I recall very vividly that Mr. Hughes asked, when these charges were read the first time, for the prosecutor to disclose what procedure he was talking about. And so that we will have instructions from our clients in relation to this procedure, this financial procedure, because they were claiming financial irregularity. So if you're claiming financial irregularity, what is the procedure you're following? Now, clearly, the entire case was completed at the prosecution's level. And they were not clear what the procedure, what financial procedure they were talking about. Now we go further than that. We looked at the statements, and this is what I'm saying. There was no witness who was brought in the prosecution's case who came into the box and completely diverted from their written statement, police statement. We saw a regurgitation of the exact thing, most of it out of the statement, unless the prosecutor wanted certain things to be amplified, then we heard more information coming to the table. But it was clear that on reading the statements, having them being disclosed, and once we received it, we were clear on this. We said, I personally said, I am shocked at the quality of investigation and work. And I'm looking at the statements and I'm saying, I am in doubt. I am in doubt that any person with legal training looked at these files and recommended these charges. Because clearly, no witness in this charge connected to the elements of the offense. And this was a case, look, if the records are there, we did not really cross-examine many of the witnesses drawn. I had cross-examined some of the main investigators in the matter. But if you look at the questions were always pointing them to, why did you charge these persons? Because clearly you couldn't have a case in which the theory says, prosecution's theory is that these standing orders review were done and completed in 2018. So you presented a case in which you're saying, listen, the parties collected monies for a job that was already done since 2018 by somebody else. So really and truly, there was no need for them to collect the money. But in your case, you brought witnesses who contradicted that theory. You brought witnesses who said clearly, these reviews were done or started in 2019. And of course, I was present. And that is what I said today. This is not even a case where you got to the defense and you were made to answer these charges and give your version of it. This case stopped at rightly so at the prosecution's case, because the prosecution has the burden in law to establish a case, a prima facie case against the person who is bringing the case, and that is really the evidential state that I'm talking about. When they would have looked at this case, I think clearly that no one with any legal sense would have anticipated that this case would go further. No, it couldn't. It couldn't. It must be that they were not interested in this case, and that clearly these cases or charges were to serve some other purpose. It could not be that a wrong was committed, and so you can justify the instituting of the charges because you're saying, well, it's in the public's interest that a wrong was committed and that matter goes before the court. Clearly. So I believe the judgment, the ruling of the court by Magistrate Weaver was a sound one. And just like we have joined as defense lawyer in asking that judgment be made available in the library and it be shared within our fraternity, because clearly there was much work that was put into that ruling, much work, all right? Because the magistrate left no stone unturned, and she showed clearly how this here could not be right. It could not be right. There was not even one limb that the prosecution was able to have success in. They failed so miserably because none of the witnesses, and they called all their witnesses. This is not a case to say that witnesses, the court forced the prosecution to close their case and witnesses were not brought. All the witnesses came to the court, and all the witnesses give evidence, and all the witnesses could not point to the elements of the offense. And that is basic. If you are going to recommend a charge, then you ought to consider what are the elements of the offense and to look at the witnesses you have. If you have 10 witnesses and you have 3 elements of this offense, you must be able, as a prosecutor, to say which witness will establish or support which ground or element of the offense. Clearly, it was absolutely from beginning to ending. I mean, it was a whole host of what I call madness, a complete waste of judicial time. All the witnesses